the book called Framed. This book is actually going to press tomorrow, and this book is the true and compelling story of local authority and police corruption, which led to an innocent man, me, being charged with false allegations of sexual offences against younger women and wrongly convicted of a crime against a 14-year-old girl who never even existed. So,
on the 31st July 2007, Brian Pead received a letter from the chairman of the disciplinary panel at Lambeth, which it stated he was guilty of 10 of the 14 charges against him. In a similar case at Lambeth, a head teacher, according to the Times Education Supplement, who was suspended from school when his deputy made false allegations about being bullied, has described the past 3 years as a nightmare, days after winning a case for unfair dismissal against Lambeth Council in 2011. James Walker, who had been head of Henry Fawcett Primary School in Kennington in London since 1999, was left feeling suicidal after being accused of bullying and harassment by an assistant head teacher in September 2008. The Employment Tribunal said the investigation process amounted to a fishing exercise which focused on obtaining the most damaging information about Mr Walker. The Tribunal was struck by the level of Lambeth's hostility towards Mr Walker. In evidence presented to the court, the Tribunal heard that the two teachers had told the Council's whistleblowing department shortly after the suspension that the deputy was fabricating her claims against Mr Walker, but this evidence was not acted upon by Phyllis Dunipace, the Executive Director for Children's Services at the time, pictured here receiving an award from Prince Charles. A bizarre allegation against Brian, which was actually dropped, regarding his employment dispute with Lambeth, was that of being pleasured by a female companion while sitting in the audience here in this very small theatre called the White Bear Theatre in Kennington, attending a performance there. And yet, strangely, why was the pub manager not informed if this incident occurred? Why were Pead and his female companion not arrested for outraging public decency? Why did the teacher bringing the complaint wait some 7 months before informing Lambeth of this alleged incident? And why did she wait until after she had herself been dismissed by Brian? Both Brian Pead and his female companion denied that the incident ever took place. Given that the theatre had no stage and the actors moved around the floor, given that the audience on the night consisted of around 20 people, and given that the lighting in the theatre is particularly strong, it is impossible that such an act, had it actually occurred, would not have been seen by others. Brian Pead decided to take Lambeth Council to an employment tribunal. He was given a date of the 14th of January 2008, some 2 years after he had been unlawfully suspended. In September 2007, while still undertaking his counselling course at the CPPD, a house was sold at 62 Days Lane, Sidcup. This house was on the opposite side of the road from Brian's house, but not directly opposite. It was at an angle of approximately 22.5 degrees. A family had previously lived there for almost 15 years, but moved away into the country. Brian and his neighbours noticed that 4 females had moved into the property. They appeared to be aged around 20 to 25. He later noticed that the curtains were closed to the right window, but they remained open on the left-hand window. Regarding the exposure case, this is the house in Days Lane where the lady is accusing Brian lived. This was Brian Pead's house, diagonally opposite and 100 feet away. The police interviewed Brian and stated that one of the incidents, which occurred on the 7th of May 2008, a Wednesday, at 11:30 p.m. in the dark, the girl is sat at her bedroom window with the light on, and her friend is also at the bedroom window with her, and the friend was stood at the bedroom door, and they say that they saw you indecently expose yourself up to the window. Notice how the PC, about the same age as the woman, refers to the 22-year-old as a girl. This was sounding more and more like Lambeth. The drama student changed her statement to say that she saw Brian at the window on the right with the blue banner in it. They claimed, her and the other drama students, that they had unobstructed views, and yet there is scaffolding all across the front of the house and a ladder. One might wonder why the woman failed to keep her curtains closed ever since she received the note back in October 2007, in which Brian had informed her that she could be seen. One also has to wonder why the police took this allegation seriously. It does not take an Einstein to work out that you could not possibly see a person's face from 100 feet away in the dark at a window which was partly obscured by 3 scaffold poles and a ladder. Furthermore, the windowsill in the front bedrooms in Brian's house were above his groin area, so it would have been impossible for anyone, let alone someone from 100 feet away in the dark, to have seen him with his hands down his trousers, as the woman claimed. On the 14th January 2008, Brian travelled to the South London Employment Tribunal in West Croydon. He represented himself. Lambeth arrived with a barrister and a flanks of Barratt Council executives, 14 in all. This in itself taught him a lot. He knew that Lambeth Council would not be sending 70 executives without reason. By sending such a large number, Lambeth was showing that they were rattled by Brian's claims against them. On the evening of the 14th of January 2008, Brian returned home and went online. He was sent a request on MSN and randomly added the person, an occurrence which happened on a relatively regular basis. Little did he know at the time how important that random act was to prove in his life. On the 28th of January 2008, the person who had been added as a contact on the 14th of January contacted Brian at 16:30 and 30 seconds. It is important to note here who was doing the chasing. It was a person purporting to be a 14-year-old girl. She had just been in a chat room and randomly asked for money for sex, stating that she was 14. At this time, January 2008, Brian was undertaking an advanced diploma in humanistic integrative counselling. Much of the contents of this course was of a psychosexual matter. He was counselling clients with significant sexual issues who had been sexually abused in the ages of 5 and 11, which started in a children's home in Harpenden, Hertfordshire. He therefore knew more about the subject of child abuse than the average person in the street. He had been deeply traumatised when it first occurred and had thereafter developed a lifelong interest in the subject from a psychological and counselling perspective. He instinctively knew, therefore, that this person claiming to be a 14-year-old girl in the chat room was not, in fact, a child at all. He knew that it was an adult, and it was his belief that it was a middle-aged male, or certainly someone with a deep interest in the subject of paedophilia. He was, of course, right. Okay, so these are 2 copies of a search warrant issued at the friend's address of Brian Pead's friends, where the computer he used, he had a conversation with a supposed 14-year-old girl acted by an undercover police officer over the internet. Now you notice here that executed is handwritten across each copy. There are 3 carbonated sheets. One goes to the court, one stays with the police, and one stays with the occupier. Nature of carbon paper is whatever's written over the top should come through exactly the same. It should be the same size, and the handwriting should be the same. Now that isn't the case here. because you'll see that the D of executed on the occupier copy is 6mm wide, and it's over the word gravelwood. On this copy it's well above the word gravelwood, close, and it's 9mm wide, so it's significantly bigger. Another interesting feature is there are two line spaces between the second and third paragraph on this particular copy, and yet strangely enough there's only one line space between the second and third paragraph on the occupier copy. Notice also that if we put the E's of executed together, one is like a half moon and one is much squarer. So something is a bit strange here. Here is a paper customer book with carbon copy paper. This is carbon paper in blue. If I write on the paper over the carbon paper, it's just under a centimetre, 9mm. And 9mm again. But the story against Brian by the police becomes even more full of holes when Geoffrey and Roy Bacon wrote using the Freedom of Information Act and the Data Protection Act of the City of Westminster Magistrates Court to obtain a copy of the police submission to the magistrate in order to obtain the warrant exercised at their address. The Magistrates Court has continually refused to provide a copy of the submission by the police. The police have continually refused to provide a copy. It is not until the 29th September 2008 that the search at the Bacon's house is mentioned in the Chris report. The warrant at Mr Bacon's address was executed on the 31st of July 2008 and computer seized. This has been examined and no further evidence obtained. Computer has been returned to owner. The emphasis is the author's. At this stage the computer had not been returned to Geoffrey Bacon, so this is a false entry. If the computer belongs to Geoffrey Bacon had been examined as this entry claims, why is Geoffrey Bacon still waiting for a copy of the forensic report which he is entitled to? He had written at least 12 letters to the police, to the forensic company that the police used on Brian's computer, and had no response with a report. Roy Bacon was not asked to sign a receipt for the return of the computer. It was not in an evidence bag. There was no chain of custody. Later that evening, Geoffrey Bacon returned home from a day's building work. He was relieved to find that his computer had been returned because he needed it to operate his business. He took it to his bedroom, he connected all the wires, he plugged it in. It did not work. The hard drive had been burnt out. This is something that greatly affected Geoffrey's business as a builder, and the authors are therefore minded to believe the accounts of two men of great integrity and with Home Office clearances to work as builders in police stations and royal buildings. Although both cases against Brian were of a sexual nature, they were not capable of being joined because their execution was significantly different. Exposing oneself to a group of 3 adult students is an entirely different act from going online and inciting an alleged child to engage in sexual acts. Indeed, the ages of the alleged victims were different. The students were in the 20 to 22 age range, and the alleged girl was 14, played by an undercover police officer. Thus, these separate indictments should never have been heard in the same court by the same jury, but the issue of misjoinder was a much larger issue because, as we have seen in an earlier chapter, in February 2009, the Crown Prosecution Service, with the same, I won't say the name, representing them, applied for joinder at Woolwich Crown Court before Judge Charles Byers. Quite rightly, Byers refused to join the two cases, stating that the two allegations did not contain a common nexus. The Crown Prosecution Service, however, would not relent. They ensured that the exposure case collapsed at Woolwich Crown Court and that it was transferred to Southwark Crown Court, a court with a higher record of convictions when compared with other Crown Courts in London. In a case of misjoinder, any conviction is automatically overturned. In R. Regina v. Newland, 1988, it was held that the misjoinder of offences is in contravention of Rule 9 of the Indictment Rules 1971 cannot be cured by a direction for separate trials of the misjoined counts. If a court proceeds to try a misjoined indictment, the proceedings will be a nullity and any resulting convictions will be quashed. At no point did Brian's barrister inform the judge and jury that the undercover policeman had produced two completely different statements. The first statement, produced in June 2008, stated that he had in fact been in the chat room on the Face Party website, but more than a year later, The police officer changed his statement, shades of Hillsborough, and denied ever having been in the Face Party chat room. This was the first of many anomalies which the Brian's barrister failed to bring to the attention of the court in one of the most abusive trials ever seen in a British courtroom. Brian's barrister tells him during the trial, "We have a problem. It appears that the Face Party IT expert is in Australia. There is an amazing oversight and abusive process. Brian wanted the IT manager called as a witness because in a case such as this, it is important that the person responsible for setting up safeguards on a social networking website is called in order to be cross-examined about his role. The Face Party website claimed in its terms and conditions that no one under 16 could access the website, and there is a considerable amount of information in the public domain to show that this is a verifiable fact. Given that Brian had read the terms and conditions and knew that the website was aimed at those aged 16 and above, he could not have reasonable expectation that the person claiming to be a 14-year-old girl was a genuine 14-year-old. With this in mind, there was no case to answer because there was no intent, yet a trial was being commenced at a great expense to the public purse. Why? However, since this trial, the authors have conducted research into Face Party and also its IT expert at that particular time of Brian's alleged offence. He has posted his current CV on the internet on several websites. An examination of his CV shows that in December 2009 he was in fact working in London. He was able to have attended the court, and his absence was not only an abusive process but also an act without the course of justice, although this is not necessarily to say that he was personally responsible for that. Brian Pead's Southwark trial was told that the Face Party website had gone into liquidation. In actual fact, the company CIS Internet Limited had actually gone into liquidation, but the Face Party website was purchased very rapidly, or ownership rapidly transferred to Anarchy Towers Limited of Langley House, Park Road, East Finchley.